for granting this interview.
Thank you.
Okay, sir. Sir, let's start with the well-being of the former President Rodrigo Duterte. Could you tell us how is he doing at the detention center, and has he requested any specific assistance from the court?
Well, I'm sorry, but as a matter of principle, we have to respect the privacy of these matters. So everything that is related to the private aspects of Mr. Duterte and any other detainees at the ICC, we cannot discuss that. We can just assure you that the court takes all necessary and possible measures to protect the well-being and the health of Mr. Duterte and all other detainees.
Okay, so maybe just an overview of how the court treats high-profile detainees. Well, not particular to the specific condition of the former president, but what kind of assistance does the ICC usually give to high-profile detainees?
It depends on their needs. As I was mentioning, the principle is to protect their well-being and their health. If there is any health issues, they have possibilities to access to medical services. They have also the possibilities to access facilities for sports exercising if they do that. Also, there are visits that are allowed to them by their defense counsel and family members and close persons according to a certain specific schedule and all other things that are related to that. They are in a detention center. It applies a different rules. It's not a prison. So there is a set of regulations that have to be respected that.
Mr. Fadi, are there any limitations, just for our understanding, when it comes to visiting the former president? Who are allowed to visit the former president at this point?
Well, there are limitations that are related to the regulations in place for that. The priority has to be given, of course, to their defense teams and to their family members. And after that, for certain close individuals, it's possible, but according to a certain schedule that has to be pre-approved.
Okay. Now I want to go to the process of the ICC. Under what conditions can Mr. Duterte apply for an interim release?
Well, for the interim release, it has to be presented to the judges, and the judges will decide if that is possible. In theory, the idea of an arrest can be decided only if it is necessary to avoid that a person will not appear before the chamber or will create problems for the investigations or will be threatening witnesses and so on. So the chamber has to check that these conditions are eventually can be mitigated by other measures. For example, to be in a specific area without possibilities to go beyond it, that there will be forces that can be checking that he will be appearing before the judges at a later stage when it is ordered and so on, and that the state in which this person may be released do accept to implement these measures and to host the current detainee and so on. So there is a process of different conditions that the judges would have to check, and if they see that there is a possibility, they may order an interim release, and if not, they can deny the request of the defense. So at the end, ultimately, the interim release request, if it is presented to the judges, will have to be subject to their decision.
Okay, but would a petition for interim release, if any, take precedence over the confirmation of charges hearing?
These are two different issues. As I was mentioning, the interim release can be requested, but it will be for the judges to decide. And one of the conditions that if there is an interim release, it has to be with conditions and measures to ensure that the person will be appearing before the judges when it is decided by them. So if there is a decision on the date of the confirmation of charges, for example, then this person would have to be present before the judges if they are ordering it. And then part of the interim release decision would be to put the measures and the conditions to ensure that this will happen.
Okay, so months ahead of Mr. Duterte's arrest, the Philippine government said while the country has disengaged from dealing with the ICC after it withdrew from the Rome Statute, but it added that it would be a different situation if the ICC taps Interpol to serve the arrest warrant. So help us understand, was there an informal communication about this mode of serving the arrest warrant, and how would you describe the Philippine government's response to the arrest warrant issued by the ICC?
Well, we are grateful for the cooperation of the Philippine authorities, and we think this is showing their commitment to the international accountability mechanisms, and this is important. Now, I don't have the possibility to discuss any thing that can be informal or to comment on the government's declarations. For us, there is a legal framework that is important, and according to this legal framework, it is true that the Philippines have withdrawn from the ICC Rome Statute, but the courts retained jurisdiction over the crimes that allegedly were committed during the period when Philippines were still state party. And this is the legal framework that gives the ICC the authority to be investigating and prosecuting charges related to the Philippines currently.
So did you expect this kind of cooperation from the Philippine government when the warrant was issued? Because you said you're grateful for the cooperation of the Philippines.
I think, as I said, we were acting according to our legal framework, and we are grateful that the Philippines showed their commitment to the international law.
Okay. Sir, in an interview with Rappler, lawyer Nicolas Kaufman, the lead counsel of former President Duterte, said the Philippine government colluded with the Office of the Prosecutor at the ICC through an Interpol diffusion to abduct Duterte. Would the ICC like to respond on that statement? Would the ICC like to respond on that statement?
I would not be responding to the defense counsel in media. When the defense counsel has any request to the judges, it will be for the judges to decide on.
All right. A key question here in the Philippines, just to help us understand the dynamics with the ICC, because there's an ongoing petition here before the Supreme Court questioning the rules on Duterte's arrest, and some are calling for it to be declared unconstitutional. Could the ICC be compelled to release him if the Supreme Court here ruled in favor of the petition for the former president?
I will not be able to comment on national justice mechanism. It's something for the Philippines, whether things can be or not declared in a certain way. For the ICC, the release of a suspect can only be ordered by the ICC judges themselves. So any request to that effect has to be submitted to them, and then we will see what are the reasons that are alleged in this request, and judges will make a decision on it.
All right. So during the initial appearance of the former president before the court, the charges cited only 43 killings for crimes against humanity. This is an ongoing debate here in the Philippines. So rather than over 6,000 deaths being reported. So how does the ICC work? For example, why only mention 43 out of the thousands of cases being reported on the war on drugs?
Well, the judges took that as a sample of the potential alleged crimes. They didn't say that this is the final number, which is potentially still open to additional requests from the prosecutor to the judges. They took that only as a sample for the purpose of the arrest warrant and not as a final charge.
Okay. Mr. Fadi, how many counsels can Mr. Duterte have, and will the ICC shoulder the expenses for some of the members of the defense team?
Well, there is always one lead counsel, and then there is a defense team. There is a minimum defense team of a lead counsel and other individuals, so case managers and investigator and co-counsel and others. And the evolution of the defense team depends, of course, on the evolution of the case, on the number of the charges, and at which phase of the process we are. Are we still at the pre-trial, or are we moving to a trial level? And of course, that might affect the constitution of the defense team and the number of members. Now, as for the legal aid program of the ICC, It's only if the judges declare that Mr. Duterte does not have the financial resources in order to cover the costs related to his defense, then the judges may grant him the participation to the legal aid program at the ICC. So normally there is a phase of financial investigation about the assets and the financial resources that a suspect has before deciding whether the costs of his or her defense should be taken over by the court or not.
All right. So just to be clear, it's not automatic that the ICC will shoulder. The former president needs to apply for that option.
There is a need first to have a financial investigation to check whether he has the financial resources or not.
Speaking of financial resources, there are also talks here in the Philippines about the possibility of ICC issuing a freeze order on the assets of the former president. At what stage does this kind of order usually happen?
Well, it can happen at any stage. It depends on what the judges consider that it is appropriate to be done. It can be a legal order issued by the judges, but I would not speculate on the judges' decisions. I always prefer to wait for the judges to make the decisions, and then we can explain what are the basis of it as they have made it public.
So could you give us like an overview scenario of what could happen during the September 23 confirmation of charges hearing? What do we expect from both the defense and the prosecution side?
I think first we need to explain what are the confirmation of charges hearings purposes. And a confirmation of charges hearing is not a trial and is not a mini trial. It's a phase in which the judges will be checking if there is enough evidence that justifies that we push a case to a trial level or to stop it at this pre-trial level. And if there is a decision to confirm one or more charges, then it's only for these charges that a trial may be held. So it's a filtering stage in order to check if really the case deserves to go to a trial or if the evidence is not sufficient for that. Because of course the evidence that are needed for the threshold of an arrest warrant or a confirmation of charges are not the same as that are necessary for the threshold of a conviction. So for a decision on guilt or innocence, the judges of a trial chamber will have to be convinced beyond any reasonable doubt about the responsibility of a certain individual. But for the pre-trial level, so for example, for the arrest warrants, it's only that there should be reasonable grounds to believe that this person may have committed these crimes. For the confirmation of charges, it's a higher threshold of checking if there are substantial grounds to believe that he is responsible. But it's only for the trial that the judges would have to check that it is beyond any reasonable doubt. So this gradual check of thresholds means also that there is a gradual discussion of the evidence on which the prosecutor would want to rely. So that's why at the confirmation of charges, it's not a mini trial, but it's a moment where the prosecutor will have to rely on a certain number of evidence, presented it to the judges. The defense will have the possibility of countering this evidence, of presenting their own evidence. If there are witnesses that are called before the judges, which is not always the case at the pre-trial level, but sometimes there are a few witnesses that may be called, then of course each party will have the possibility to cross-examine the witnesses called by the other party. It's also important to highlight that during the confirmation of charges, the victims may also be authorized to be participating in the process through a lawyer. So during this period between now and September, the prosecutor may be requesting additional requests to the judges, the defense as well, but also there is a work that will be done in order to allow victims who wish to participate to the proceedings through a lawyer to do so and to apply for it. The participation is of course free of charges, but it is a separate process from the reparations process. We are not speaking about reparations at this moment. Reparations can be discussed only if a person is declared guilty after trial. We are only speaking about the participation of the victims to present their own views and legal observations as well before the judges during this pre-trial phase.
So if the prosecution would be able to secure a trial, could you give us an idea of how long of a legal battle will this be for the former president, at least based on the how the ICC usually works when if there's a trial?
It's extremely difficult to make a prediction about the duration because everything will depend on the charges that may or not be confirmed. In the past, we had different types of cases before the ICC. Some of them for trials took years, others took 1.5 years. And some just took a couple of weeks because there was an admission of guilt by the accused himself. So the issue of the duration of a trial, if we get to a trial, and we are not at the trial level at this moment, we are still at the pre-trial, as I mentioned. But if there will be a trial in the future, it's not possible to predict at this moment how long it will take. What I want to insist on, of course, is that we have to fully respect the rights of the defense, including the presumption of innocence. And that's why I'm kind of speaking in general and in the past experiences of the ICC and not specifically about this case, because at this moment we are still at a pre-trial stage and there is no decision on the confirmation of charges, of course.
So 43 charges. Does the ICC, do the judges need to confirm all, or does it only need a minimum number of confirmation of charges for a trial to proceed?
Well, it might be different system for the ICC than what is in the national laws. For the ICC, as I mentioned, the judges have took a sample of this 43 incidents, but the charge itself is a charge of a murder and a crime against humanity. So this is the charge, and then there are incidents related to this charge. During this coming period, as I mentioned, there may be requests from the prosecutor to add charges or to add incidents to this charge. And then this is what the judges will have to decide on, whether or not to confirm the charge of a murder as a crime against humanity, and of course, if there are subsequent requests as well on that. So it's not 43 different crimes. We look at it as the crime of murder as crime against humanity, and this is the charge that will be discussed as we know actually.
All right. In the event that the judges see or acquit the former president during the confirmation of charges, or there is no confirmation of charges, does it mean that the president can go home right away, or there will be processes before that happens?
Well, at the ICC, we don't use the term acquittal for pre-trial level, nor we do use the word conviction. At a pre-trial level, there's only the question whether or not charges would be confirmed against a suspect. If no charges are confirmed against a suspect, then of course the case should end at this level. There's a possibility for the parties, so either the prosecutor or the defense, to request a leave to appeal the decisions on the confirmation of charges if they are not satisfied with the outcome, and that's a different process. But in principle, if, for example, there is no appeal or the leave is denied, then of course, when there is no charges confirmed, the case ends and the suspect is released.
All right, sir. As last question, there are calls for the Philippines to rejoin the ICC. Can the Philippines rejoin the ICC, and what steps should the government take to rejoin?
We call on all states, including the Philippines, to join the ICC Rome Statute. It's important for the international criminal law, for the peace around the world, and for the future. Also, we believe that a lasting peace in all the regions of the world depends on the justice, and international justice mechanisms are only part of this justice scene. Now, of course, the Philippines have withdrawn from the ICC statute, but they can join again through the process of ratification. And of course, the instrument of ratification decided by the Philippines, which is a sovereign decision that we fully respect whether to join again or not. But if they want to join again, then the instrument of ratifications needs to be deposited, as it is always the case with the UN Secretary General, because his office is the depository of international treaties.
All right. Thank you so much for sharing your insights and your time. ICC spokesperson Fadi El Abdallah joining us from the Netherlands. Sir, thank you for this interview.